At this time, I'll open the public portion. Anyone from the public have anything to say this evening? Yes, ma'am. Come up front, your 3 minutes, and your name and address, please.
Deb Bird. I live at 21 Redwood Line, Mansfield Meadows. And I'm here to ask for an update on the site distance. Where are we going with this? This is a public safety issue. And as far as I know, the Township Committee's role in this is to protect the safety of its residents. And we've got as Mr. Kwan said, it's almost complete. We've got 400 or so cars coming in and out of that development. Route 57 is busy. And what is going to be done? Does the township have any plans? You put the developer on notice back in November or October of 2025. You gave them 14 days to conform or to come up with a solution, or you were going to do everything you could under the law to make him fix this problem.
Where do we stand, Rich?
Yeah, a letter was gone out by the attorney, conflict attorney, and he sent a letter basically giving them an ultimatum. So they need to comply. They're gonna have to comply in order to finish out the job. So whether it's tomorrow or in a couple of months, they'll have to comply.
Yeah, but to leave a public safety issue like this go on for 2 years is horrible. I can't tell you how many close calls I've seen out there.
Yeah, we agree 100%. We're doing the best we can to make them do it, and
Well, there's things in the developer's agreement that give you some leeway. You can do a stop and desist order. And I think if you would have done that probably a year ago, I think Ryan Holmes and the developer would have quickly come to a conclusion.
Probably stop work. I mean, I have a counselor for it, so I don't want to say too much, but check the father.
Yeah, I'll have to check with Bob, the conflict attorney.
And in the amendment approving the 8 additional homes, it says they have to comply. They have to have all the permits and approvals from outside agencies before you could go on and improve the amendment to the development. The 8 houses, right in the resolution says it will not have any negative effect on the development or the people in it. Well, it did. You've got an unsafe site distance. Okay,
thank you,
all
Ms.
right.
We will, we're working on it. It's not happening as quick as I would like, but I was unaware we could put a stop work order, but maybe that's the mission we should hear.
Thank you.
Thank you. Anyone else? Ms. Thompson?
Good evening, Carol Thompson, I-10, Route 57, Fort Mary, New Jersey. I haven't heard from the town in regards to my situation, in regards to the junkyard and them breaking out their crushed cars, storing them outside. We have zoning to protect and preserve our property values and also to control unacceptable prohibited uses. The burden placed on our neighborhood by zoning non-enforcement continues. Our quality of life is affected. The offensive expansion of the junkyard, where the primary use was changed to house a used car business, is now storing, parking, displaying junkyard operations. It's a nuisance, causing harm to the character of our neighborhood. The failure of the zoning officer to apply the law according to municipal land use ordinances and not upholding the integrity of the land use board is the cause it continues. If New Jersey Cars wishes to operate their junkyard business outside of the fence, That was a restriction placed by this township committee in 1953. New Jersey Cars was advised the legal process by the land use board to seek proper approval and follow the lawful channel. The zoning officer has been inconsistent in his duties, allowing junkyard operations in front of the closures. There's a car parked there tonight because apparently they can't get in it to move it. For 1 year after the adoption of the ordinance, the zoning officer only has the right to make a determination in the scope of the pre-existing use. Otherwise, the only other entity is the land use board, and they have made their determination. They found improper actions contrary to ordinance, and the zoning officer does not uphold the integrity of the land use board. That's a clear abuse of discretion. He states there's no expansion of the non-conforming use. The non-conforming use is only the used car dealer. And they're only entering and exiting through the gate, and he'll no longer take calls regarding this subject. Zoning is a legal issue, and the zoning officer is enforcement of law. His opinion is of no force and effect. Contrary to ordinance, the use of the property was created in 1953 by an agreement put in a chain of title by the township and the neighbors, because the neighbors opposed a junkyard. The historical restrictions to limit a portion of the property were agreed to. His opinion is of no force and effect. He has no power to make zoning determinations. Personal views are improper and not legal, and he has no power to shut his eyes. The land use board determination concluded anything under control of the junkyard is to be stored, parked, displayed behind the enclosure. The resolution was appealed in Superior Court and went through an independent review. What is this town gonna do to make the zoning officer do his job? Nothing?
When you're done with your public comment, don't respond. I don't think your time's up.
Okay.
So I think the zoning officer is doing his job. In order to get the junk cars into the junkyard, they have to have them on a flatbed, they have to open the
Okay,
gate
yeah,
and drop
that
it
is
in.
not what's happening,
So-
that's not what's happening.
Well, he sent me pictures of it, and that seems to be what's happening
Well,
from photographs.
That's not what's happening, you know what's happening, well, it's been
Mr.
happening
Johnson,
for
we've had
17
this
years.
conversation many times.
Yes, we have.
10 years ago, they were illegally selling used cars in the front of that property.
And
they
bringing
were not
junkyard
allowed-
outside too.
So they're doing a lot of different things. So since that time, they cleaned it up. Violations were issued, they cleaned it up. In order to have a junkyard in New Jersey, you have to have a used car dealer's license. That doesn't mean you can use a used car lot. So they have that, and they have to have that every year.
That's not the
But-
problem.
But I
The
understand.
problem is the junk and scrap and their operations brought out
Okay,
and stored
your
in front
time
of
is
the
up.
enclosure.
I thought I answered your question.
You did not.
Okay.
When is the zoning officer gonna do his job?
Your time's up.
When is the zoning officer gonna do his
I
job?
believe the zoning officer is doing it.
He is not doing his job, they're out there every day.
Mrs. Thompson, your time is up.
Anyone else?
Good evening, with services, we're terrorists. I want to say something. Coming out of the heels of what's just going on, New Jersey courts have repeatedly held that public office is a public trust. In Thompson v. City of Atlantic City, the Supreme Court said that municipal officials owe undivided loyalty, okay, to the public good, and must avoid even the potential for conflicting interests that erode public confidence. The court explained that the residents are entitled to the disinterested service of their elected officials, and that even the likely capacity to tempt an official away from that sole public duty can require disqualification. That principle exists because government transparency and public oversight are not side effects. They are central to the public trust itself. At the April 8th, 2026 Township Committee Meeting, Committeeman Michael Bollard proposed reviewing Mansfield Public Recording Ordinance 2018-02. He raised legitimate concerns about the vague language and the severe penalties tied to the recording public meetings, including fines of up to $2,000, 90 days in jail, and community service. He specifically referenced the Supreme Court's decision in Torres v. Borough of Pine Hills. recognizing the public right to videotape open meetings subject to reasonable restrictions. The township attorney, Mr. Lavery here, specifically references, specifically agreed with this, and saying that videotaping open meetings is subject to restriction. He even said that it's probably not a bad idea. He explained the ordinance was drafted when large equipment was back then in, I don't know, decades ago, and disruption concerns were a concern. That's no longer the case. Then committeeman Brent Connolly admitted he had never read the ordinance before that meeting and did not know it existed. Despite that, he still opposed moving forward with a review. Okay? More troubling, his position became that nobody had been prosecuted yet. Okay? Therefore, the ordinance was not important enough to review. That concerns me greatly. Okay? When an elected official opposes reviewing an ordinance affecting constitutional rights and admitting he had not even read it beforehand, residents have every right to question whether the public interest is truly guiding the decision-making process, as we've heard here before, right? In a 5-member committee and 3 votes control ordinances, contracts, appointments, litigation strategy, and major spending decisions. That concentration of power demands heightened transparency, not resistance to public oversight.
It's just.
No, it's not. I'm telling you right now.
No, it's not.
What do you mean? I'm telling you right here.
No, I'm
This
just
is
probably here in a
this is-
second, but, I mean,
This
you're
is
the one,
what-
listen, you're the one that wanted us to enforce the
And it's, I mean,
ordinance,
it's ridiculous. I'm looking at my stopwatch as I do this. You're lying.
I'm not lying.
You're lying. Why are you- Listen.
You got 38 seconds left.
Yeah, let me finish, all right? So when elected officials oppose reviewing ordinances, that's a constitutional violation, Mr. But the public interest is truly guiding the decision-making process. Okay, so now, under this Thompson Supreme Court decision, public officials must avoid conduct, creating even the appearance of political discomfort. Residents here, everybody here deserves confidence that the decisions that are being made by this committee are being made for the benefit of the public, not for the convenience of those of you guys or anybody holding power. So remember, and there's actually 4 Supreme Court cases, presidential, that say exactly the same thing. Public interest, don't forget it. Just because you're sworn in, you forget, don't forget this stuff, please. Thank you.
Is our ordinance considered unconstitutional?
I don't think it's unconstitutional.
No, your actions
Now,
are.
that-
Your actions are.
Exactly.
No, don't deflect, okay? You know what you're
Mr.
talking about.
Sozis, stop, please.
Well, tell him, you're the attorney, you should know this stuff.
I answered this question, then you interrupted me from the audience, so let's be
I
fair.
apologize. I didn't hear that.
I hope we're done.
Any further comments from the public?
I'm Osric East, 67 Lane. I guess it's my last ditch effort here. This is in reference, so when did the ordinances go into effect, the wood burning furnace that we were explaining? When, because they're not in effect right now, I just checked on my phone. And it's not updated right now, so I don't know when they actually go into effect.
I think it's in effect when we voted.
Yes.
You're right, that's,
Yes.
but you're talking the website.
Well, yeah, the website, I don't know, so is it not?
But it takes time for the website to be updated, right?
Okay, so one on agenda, I got very little time on, I don't need to know, it's irrelevant. So if you took out that it was to be burned from May to October, I wasn't at that meeting, you said I wasn't at the meeting, I've been at every meeting. I explained that I didn't want anything happen to neighbors. I just want to know how many other families or households were affected with this exterior wood furnace made for October. Because you'll vote on it, or you'll saw it, there was outcry for having those months be burned, so I want to know how many families were affected, other than, I want to know how many families were affected. Because there's 3 households that are affected by it being burned May for October, it's not affected. I'll get to the punch. There's a thing called the grandfather clause. And I know it's brought up at one meeting, but it's just kind of schemed over. This hasn't been really even brought up to effect yet. It hasn't been published. I say that maybe the people that are affected by it should be grandfathered claused in, and then it can go into effect. So anyone moving forward can have the ordinance, and anyone not affected by it now should be grandfather claused in. And it can be done by time and however you guys decide. So I don't see why that was taken out. So it's not an ordinance, it's a big county, it's a big decision. 220 feet or 2 acres is not a lot of room for a wood furnace. We have smoke coming down from Canada with fires. So 220 feet or 440 feet is not far. So again, May through October, I just want the people that are affected by it should be affected. But I know there's more households affected by it than aren't. That's it. Thank you. Thank you. Oh, thank you so much.
Anyone else? Seeing none, close the portion.